A federal courtroom just exploded into total chaos. Judge Eleanor Caldwell slammed her gavel so hard that people say the sound echoed through the marble hallways. She ordered federal marshals to arrest someone right there on the spot. Not a defendant, not an angry witness, but someone far more unexpected. And the reason? A secret recording that was never supposed to be heard by anyone. Witness 14, a protected government informant whose identity had been kept secret for 18 months, just leaked audio that prosecutors desperately wanted hidden. 3 minutes and 47 seconds of tape that caught something so bad, so guilty-looking, that the moment it came out, everything about this case changed. Here's what mainstream media isn't telling you about what's actually on that recording. So, what caused this unbelievable courtroom explosion? At around 2:47 p.m. Eastern yesterday, an encrypted audio file showed up at the same time on 4 major news platforms. The source was Witness 14, who had been living under federal protection since March of last year. The contents are a recorded conversation that directly goes against sworn testimony given in open court just 6 weeks ago. This isn't just another leak. This isn't some angry former employee trying to get revenge. This is a protected federal witness, someone the government vouched for, someone prosecutors built their entire case around, going rogue in the most spectacular way imaginable. The recording captures voices that legal experts have already identified. The conversation discusses actions that, if proven real, would be multiple federal crimes. And the timestamps on the metadata place this conversation at a time when every person involved was supposed to be somewhere else entirely. Judge Caldwell's arrest order came within 90 minutes of the leak going public. Federal marshals are now hunting for Witness 14, whose location remains unknown. And I have the transcript of that recording right here. Let me show you exactly what they said and why it changes everything about this case. Here's what the leaked recording actually reveals. The audio begins in the middle of a conversation. 2 voices are clearly heard. The first voice, which 3 independent audio experts have now matched to Deputy Director Marcus Holloway, states, and I'm quoting directly from the authenticated transcript, "The evidence chain is compromised. We knew that before the grand jury convened. The question is whether it holds up. The question is whether anyone looks close enough to notice." This is it. This is what everyone's been talking about. The second voice responds, and if the defense files for discovery on the original chain of custody, Holloway's alleged response, "They won't find what we didn't preserve." According to legal experts who reviewed this transcript within hours of its release, this exchange suggests evidence tampering at the highest levels of the investigation. Former federal prosecutor Daniel Whitmore told Reuters that the conversation describes textbook obstruction, the kind that ends careers and begins criminal investigations. The recording continues for another 2 minutes, during which the voices discuss specific dates, specific evidence items, and specific witnesses whose testimony was allegedly coordinated before trial. At the 2014 mark, Holloway's voice allegedly states, "Witness 14 is handled. They know what to say and when to say it. The deposition is already written. They just need to memorize it." This wasn't witness preparation. This was witness manufacturing. The metadata embedded in the audio file indicates the recording was captured on January 17th of this year, 12 days before Witness 14's grand jury testimony. The location data suggests the conversation happened inside a federal building in downtown Washington. But here's the kicker. The most explosive part comes in the final 40 seconds. A third voice enters the recording. This voice, which audio experts are still working to identify, asks, "What about Caldwell? Does she know?" Holloway's alleged response, "She knows enough. She's not asking questions she doesn't want answered." That single sentence has triggered immediate calls for Judge Caldwell's removal. It suggests the judge knew about prosecutor misconduct. It implies a coordinated effort to prevent the defense from accessing evidence that could help them. Legal analyst Sarah Chen told MSNBC that this part of the tape fundamentally undermines the integrity of these entire proceedings if Judge Caldwell had knowledge of evidence manipulation and failed to act. We're looking at judicial misconduct charges that could end her career. The transcript reveals additional damaging details, references to at least 3 other witnesses whose testimony was allegedly coordinated, discussion of evidence that was archived rather than disclosed to defense lawyers, explicit acknowledgement that Brady material evidence favorable to the defendant, that prosecutors are legally required to disclose was deliberately withheld, and a reference to the contingency plan if any of this became public. And it gets worse. In the final 10 seconds of the recording, just before it cuts off, Holloway's voice allegedly states, "If this goes sideways, Witness 14 takes the fall." That's the arrangement. That's what they agreed to. Witness 14 apparently heard that and decided the arrangement no longer worked for them. Former Justice Department official Rachel Morrison emphasized that the implications extend far beyond this single case. What this recording describes, she told NPR, is not an isolated incident. It's a system. If these practices existed here, they exist elsewhere. This could trigger reviews of hundreds of prosecutions. Smash that subscribe button right now because this story is developing by the hour. I'm releasing updates as they happen, and you won't want to miss what comes next. Hit subscribe so you see every video on this case. Now, you've seen what's on the tape, but here's how we got here, and it makes this revelation even more devastating. This case began 22 months ago with what the Justice Department called the most significant public corruption investigation in a generation. The defendant, whose name remains partially sealed due to ongoing proceedings, faced 17 federal counts ranging from bribery to obstruction to conspiracy. Witness 14 emerged as the prosecution's star witness last March. According to court filings, this individual had direct knowledge of the alleged criminal conduct, had participated in key meetings, and had preserved documentation that prosecutors described as undeniable evidence of guilt. The witness's identity was sealed under a protective order that Judge Caldwell personally approved. The reasoning? Witness 14 faced credible threats and required federal protection to ensure their safety before trial testimony. Everything changed on February 3rd, when defense attorneys filed a motion challenging the evidence chain of custody. The motion, which was heavily redacted in public filings, alleged systematic irregularities in how physical evidence was collected, stored, and cataloged. Judge Caldwell denied the motion within 72 hours. Her ruling stated that defense claims were speculative and unsupported by credible evidence. She prohibited defense lawyers from deposing the evidence custodians directly. At the time, legal observers noted the unusual speed of her ruling. Defense attorneys filed an immediate appeal. That appeal was pending when the recording leaked. According to sources familiar with the investigation, Witness 14 had grown increasingly concerned about the prosecution's methods in recent weeks. The witness allegedly requested a meeting with the lead prosecutor on March 1st, a meeting that sources say ended with raised voices and an abrupt departure. 2 weeks later, Witness 14 missed a scheduled pretrial preparation session. Federal marshals were dispatched to the witness's protected location. They found the residence empty, the security monitoring system disabled, and a handwritten note that read, "Check your evidence." Prosecutors attempted to seal this development. Judge Caldwell granted their motion. The public knew nothing about Witness 14's disappearance until yesterday, when the recording surfaced with a simple message attached. They lied. I have proof. The truth deserves to be heard. Within hours, the story exploded. Judge Caldwell's sealed orders became irrelevant. The protective order meant to shield Witness 14 now applies to a fugitive. And the prosecution's entire case built on testimony from a witness who has now publicly accused them of misconduct teeters on the edge of collapse. Hit that like button if this is connecting the dots for you. I know this is complex, but the details matter here. Drop a like to let me know you're following and leave a comment telling me what part shocked you most. The bombshell moment came at 4:23 p.m. Eastern when Judge Caldwell reconvened the court for an emergency session. Reporters inside the courtroom describe an atmosphere unlike anything they'd witnessed in decades of covering federal trials. The gallery was packed. The defendant's legal team sat stone-faced. The prosecutors looked, according to one observer, like they'd seen their careers flash before their eyes. Judge Caldwell entered without her usual acknowledgement of the room. She didn't sit. She stood at the bench, both hands gripping the wooden surface, and addressed the court in a voice that witnesses described as barely controlled fury. This court has been made aware of an unauthorized disclosure of protected materials, she stated. The individual identified as Witness 14 is hereby ordered to surrender to federal authorities within 24 hours. Failure to comply will result in immediate issuance of a federal arrest warrant on charges of contempt of court, violation of protective order, and obstruction of justice. The room fell silent. Then Caldwell added something that made the moment truly extraordinary. Additionally, this court is referring the matter of the recording's contents to the Justice Department's Office of Professional Responsibility for immediate investigation. She was referring the allegations against her own prosecution team. She was, in effect, acknowledging that the recording contained claims serious enough to warrant investigation. That's when it became clear this isn't just another courtroom scandal. This is the possible unraveling of a federal prosecution from the inside out. Don't go anywhere. The historical context on this is critical, and what comes next changes your entire understanding. Drop a comment right now. Do you think Witness 14 is a hero or a criminal? I read every single comment. This isn't the first time a protected witness has turned against the prosecution, but the scale of this betrayal is virtually unprecedented. Think back to the Whitey Bulger case in Boston. FBI handlers had protected Bulger for decades while he committed murders. When the truth emerged, it destroyed careers, triggered congressional investigations, and fundamentally reshaped how federal agencies handle informants. The fallout lasted 15 years. Then there was the Ted Stevens prosecution in 2008. A federal jury convicted the Alaska senator on corruption charges, only for the conviction to be thrown out when it emerged that prosecutors had withheld evidence that could help him. Attorney General Eric Holder personally moved to dismiss the case. The lead prosecutor was later found dead of suicide. The Justice Department implemented new disclosure requirements that remain in effect today. The key difference now? Technology. In previous cases, evidence of misconduct emerged gradually through legal filings and investigations that took months or years. Witness 14 bypassed that entire process by going directly to the public through an encrypted file dump. There's also the matter of the recording itself. In the Stevens case, misconduct was proven through documents and testimony. Here we allegedly have voices. We have timestamps. We have metadata that can be forensically verified. The pattern is clear. When prosecuted misconduct surfaces, the consequences extend far beyond the original case. Convictions get overturned. Prosecutors face discipline. Public trust in the justice system erodes. Now, however, we're seeing something new. A protected witness didn't just refuse to testify, they didn't just take back their story. They actively collected evidence of the alleged misconduct, preserved it, and strategically released it to ensure maximum public impact. If Witness 14's claims are verified, this could trigger the most comprehensive review of federal prosecution practices in modern history. Every case this team touched becomes suspect. Every conviction becomes appealable. Legal experts are calling this situation unprecedented in modern federal court history. Jonathan Turley, constitutional law professor at George Washington University, told Fox News that the recording represents a potential extinction-level event for this prosecution. If the audio is authenticated and the statements are as damning as the transcript suggests, we're not talking about a mistrial. We're talking about criminal referrals for the prosecutors themselves. Turley emphasized that the reference to Judge Caldwell is particularly explosive. The suggestion that a sitting federal judge had knowledge of evidence manipulation, even passive knowledge, triggers immediate recusal requirements. If she doesn't step down voluntarily, the defense will file within hours. Meanwhile, Ellie Honig, former federal prosecutor and CNN legal analyst, emphasized a different dimension of the crisis. What strikes me about this recording is the casualness of the conversation. These aren't people worried about getting caught. This sounds like standard operating procedure. And that should terrify everyone who believes in equal justice. Honig added that the reference to Witness 14 being set up as a fallback creates an additional legal problem. If the prosecution planned to scapegoat their own witness if things went wrong, that's conspiracy. That's potentially witness tampering. And it gives Witness 14 a powerful defense against any contempt charges. They were protecting themselves from a coordinated effort to destroy them. A former federal judge who requested anonymity to speak freely admitted that Judge Caldwell faces an impossible situation. If she recuses now, it looks like an admission of guilt. If she doesn't recuse, every ruling she makes will be immediately appealed. Either way, this case is effectively over as currently constituted. Even supporters of aggressive prosecution tactics are struggling to defend what the recording allegedly contains. Former prosecutor Andrew McCarthy wrote in National Review that if these statements are accurately attributed and authentic, there is no defense. This isn't aggressive lawyering. This isn't pushing boundaries. This is the deliberate corruption of a criminal proceeding. Neil Katyal, former acting Solicitor General, noted that the implications extend to the institutional level. The Justice Department has spent decades building credibility in federal courts. This recording, if verified, represents a betrayal of every principle prosecutors are supposed to uphold. The damage won't be measured in one case. It will be measured in the erosion of judicial trust that takes a generation to rebuild. Do me a favor and slam that like button right now. It genuinely helps this video reach more people who need to see it. The algorithm rewards engagement, and your like helps break through the noise. Hit it now. So, what does this actually mean going forward? First, this case is almost certainly headed for dismissal or mistrial. The defense has already filed an emergency motion citing your recording as grounds for immediate dismissal with prejudice, meaning the charges could never be refiled. Judge Caldwell has until Friday to rule, but legal observers believe she'll likely recuse before that deadline. If she does, the case gets reassigned. All previous rulings become subject to review, and the trial calendar resets to 0. This puts both the prosecution and defense in extraordinary positions. Prosecutors must now defend not just their case, but themselves. Defense attorneys suddenly hold leverage they never anticipated having. Second, Deputy Director Marcus Holloway faces immediate career consequences. The FBI issued a statement last night confirming that Holloway has been placed on administrative leave pending an internal investigation. Sources within the Bureau described the mood as shell-shocked. Holloway had been on the leadership track. His name had appeared on short lists for senior positions. Now he's hiring criminal defense attorneys. 3 other officials mentioned tangentially in the recording have also been placed on administrative leave. The Justice Department's Office of Professional Responsibility has opened a formal investigation that sources say will take months to complete. Third, the precedent this sets for future whistleblowers is extraordinary. Witness 14's actions violated multiple laws and court orders. They potentially compromised an ongoing federal investigation. They're now a fugitive facing federal charges. But they also exposed what appears to be systematic prosecutor misconduct. The public debate over whether Witness 14 is a criminal or a hero has already begun, and how that debate resolves will influence whether future witnesses in similar positions stay silent or speak out. Legal scholars note that existing whistleblower protections don't clearly cover this situation. Witness 14 wasn't a government employee protected by statute. They were a cooperating witness who turned against their handlers. This gray area could trigger congressional action to clarify protections or to create new penalties for witnesses who breach protective orders. The implications for public trust and federal prosecutions are profound. Every defendant currently facing charges brought by this team will file motions citing this recording. Every conviction secured by these prosecutors becomes potentially vulnerable to appeal. Defense attorneys across the country are already preparing challenges based on the patterns allegedly described in the tape. If the recording is authenticated and multiple forensic analyses are currently underway, it doesn't just destroy one case. It creates a template for attacking federal prosecutions nationwide. Defense attorneys will argue that if this happened here visibly with recording evidence, it happens elsewhere invisibly. The Justice Department understands this. Their response in the coming days will be calibrated not just to this case, but to the institutional credibility of federal prosecution itself. And then the prosecution made it even worse. Instead of acknowledging the seriousness of the allegations, lead prosecutor Victoria Mansfield held a press conference that legal observers are calling catastrophically ill-advised. "This recording is stolen property," Mansfield stated. "It was obtained illegally, edited deceptively, and released to interfere with an ongoing federal prosecution. We will not be intimidated by criminals who violate their legal obligations." She called Witness 14 a manipulated source who has been compromised by defense interests. She described the recording as selectively edited to create a false impression. She refused to answer questions about the specific statements attributed to Deputy Director Holloway. Here's the problem with that response. It addressed everything except the content of the tape. Not once did Mansfield deny that the voices on the recording were authentic. Not once did she explain the references to evidence manipulation. Not once did she address the claim that Judge Caldwell knows a nuss. Jonathan Turley pointed out that the response was legally incoherent. You can't simultaneously claim a recording was deceptively edited while refusing to identify what was edited or how. Either you challenge the authenticity directly with evidence, or you address the substance of what was said. Mansfield did neither. Former federal prosecutor Renato Mariotti called the press conference a masterclass in how not to respond to a crisis. She validated the recording's importance by attacking the source rather than the content. Every defense attorney in America is now going to use that press conference in their motions. When your defense is attacking the messenger rather than addressing the message, you've already lost the argument. The fallout from Mansfield's response has been immediate. 2 attorneys on her team have requested reassignment. Sources within the Justice Department described senior officials as furious at the press conference. An internal memo reportedly circulated last night ordering all team members to make no further public statements. Meanwhile, the recording continues to spread. Every major news outlet has now analyzed it. Audio forensic experts are publishing their findings in real time, and the public is drawing its own conclusions about why the prosecution is attacking Witness 14 rather than answering simple questions about what's actually on the tape. But beyond the immediate legal and political fallout, this is really about something much bigger. This is about whether we have a justice system or a conviction machine. The recording, if authentic, describes prosecutors who viewed witnesses as props, evidence as malleable, and judges as cooperative participants in predetermined outcomes. It describes a system where the goal wasn't finding truth but securing victories. If this goes unchecked, if there are no consequences for what that tape allegedly reveals, it signals that federal power operates without meaningful oversight. It tells future prosecutors that misconduct is acceptable as long as you win. It tells future defendants that the deck is stacked before they ever enter a courtroom. This affects every American, regardless of political affiliation, liberal or conservative, Republican or Democrat. Nobody benefits from a justice system that operates in the shadows, that withholds evidence, that manufactures testimony. The question isn't whether Witness 14 violated their protective order. They clearly did. The question is whether their violation exposed something so fundamentally corrupt that the public had a right to know. That's what courts and ultimately history will have to decide. Subscribe right now if you want to see how this unfolds. I'm covering this story every single day as new developments break. Hit that subscribe button and turn on notifications so you never miss an update. This is far from over. Here's where things stand right now. Witness 14 remains at large. The 24-hour deadline Judge Caldwell imposed expires at 4:23 p.m. Eastern today. Federal marshals have issued a nationwide alert. Sources indicate that witness 14 may have left the country, though this remains unconfirmed. Judge Caldwell has not yet ruled on the defense motion for dismissal. She has also not responded to mounting calls for her recusal. Her office issued a one-sentence statement. The court will address all pending matters at the appropriate time through appropriate channels. Deputy Director Marcus Holloway remains on administrative leave. His attorney released a statement calling the recording a sophisticated fabrication designed to undermine a legitimate prosecution. The statement provided no evidence supporting the fabrication claim. According to CNN legal analysts, at least 4 forensic audio laboratories are currently analyzing the recording. Preliminary findings from 2 labs suggest the audio shows no signs of editing or artificial manipulation. Final reports are expected within 72 hours. The defendant's legal team has scheduled a press conference for tomorrow morning. Sources indicate they will call for immediate dismissal and for criminal referrals against the prosecution team. Meanwhile, congressional interest is building. Senator Richard Durbin, chair of the Senate Judiciary Committee, has requested a briefing from Justice Department officials. Representative Jim Jordan has called for public hearings. Keep a close eye on Judge Caldwell's decision on recusal. If she steps down, this case enters uncharted territory. If she refuses, the appeals court will likely force the issue within days. The next 48 hours will determine whether this becomes a scandal that burns out quickly or a conflagration that consumes the entire prosecution. The evidence is on tape. The accusations are specific. The consequences are already unfolding. What happens next will define whether federal prosecutors operate under the same laws they enforce or above them. Witness 14 took an enormous risk. They broke their agreement. They violated court orders. They became a fugitive. But they also handed the public something it rarely receives: a window into how power actually operates when it thinks no one is recording. This isn't just another legal scandal. This is a test of whether accountability means anything at all. Subscribe so you don't miss what comes next. Hit that notification bell. Share this video with someone who needs to see it. The reckoning is just beginning.